Hey Doug, do you have our security guys' information? Do you have our security guys' information?
No, nobody said a word to me about getting any security.
Okay, can I forward you his phone number? Because I can't use this phone now. And can you give him a call? Because he's over there somewhere. He's looking for us.
Oh, he is?
Yeah. Okay, I'm going to forward you the email right now. Thank you, Doug. I emailed it. Yeah. Yeah. All right, good morning, everyone. It is a Supreme Court opinion day. We've had a little bit of activity this morning outside the court already. Two pro-choice protesters jumped the small fence in front of the court and handcuffed themselves to the larger fence. You can see right behind me there's a lower fence and then there's a higher fence. So the protesters jumped the smaller fence and handcuffed themselves to the taller fence. They were pretty quickly and efficiently removed. Officers clipped the handcuffs and then took them. I couldn't tell if it was handcuffs or zip ties, but removed them from the premises. So there's a pretty healthy group of protesters. You can see my camera is a little, I don't know why it's turning. Sorry, guys. So you can see the protesters there. And we've got a healthy group of officers who are now walking down toward, you'll see them walking behind me in just a second, who are now going to make sure, essentially, that no one jumps the smaller fence, which is what just happened. So everyone is okay, nobody injured. We are expecting Supreme Court opinions in 24 minutes. So we also got orders this morning at 9:30, and the Supreme Court granted two new cases, one on the False Claims Act and one on the Bank Secrecy Act. So many people have said Kim Wexler from Better Call Saul. I don't know who, I don't watch that show, but I'll have to go look. So the way that this goes, at 10 a.m., the Supreme Court will release one or more opinions from an argued case this term. That means a case that has been fully briefed, the court had oral argument, the court has had time to decide and vote and write a full opinion. There are 18 outstanding cases that have not yet had opinions released this term. We already know today's not the last day of opinions because at the very least the Supreme Court will also be releasing one or more opinions on Thursday. But they have a lot to get out. They usually, not always, but usually get all of the Supreme Court decisions out by the 4th of July holiday weekend. And they seem to be on track to do that. So I would expect that we don't get all 18 opinions this week and that we get some next week as well, but you never know what the court's going to do. We could get 10 opinions today. Who knows? So I expect we'll get more than one this morning, but that'll begin. Hi, how are you? Hi, good morning. I'm Katie. Mark? Anthony, Mark. Thank you, guys. So I'm live streaming here for a little while, and then I may have to jump over into the crowd if things happen. Just a minute ago, a couple of people jumped the fence. I think that's why they're bringing these. Yeah, they jumped a smaller fence and then handcuffed themselves to the taller fence, but they were quickly removed. But they've now added Capitol Police officers between the barricades.
We're here with you all day, whenever you need.
Cool. Thank you. All right, so you guys can see behind me, some officers have now stepped in. These are Capitol Police officers who have now stepped in between the two barricades. And that's because two individuals just a few minutes ago hopped the smaller barricade and then handcuffed themselves to the taller one. Somebody asking about the Bank Secrecy Act. That was a new grant this morning. So that the issue in that case is whether a violation under the Bank Secrecy Act, quote, violation under the Bank Secrecy Act, is the failure to file an annual report of foreign bank and financial accounts, no matter the number of foreign accounts, or whether there's a separate violation for each individual account that was not properly reported. All right, guys, so it's opinion day. We're going to get one or more opinions from the Supreme Court beginning at 10 a.m. The way that this goes, for those who are new or who are just joining or who are unfamiliar, when the Supreme Court begins releasing opinions, they will do so on their website. You can join if you want to follow along. It's at supremecourt.gov, and you just click Opinions of the Court in the top left, and you can also see the opinions come out as we do. If there are multiple opinions, which I suspect that there will be, they will be released in 10-minute increments throughout the morning. So the first one will be at 10. If that's not the final one for the day, the second one will be at 10:10, then 10:20, then 10:30, then 10:40, then 10:50. If we get that many, which we did last week, we got 6 on Wednesday last week. So it's certainly possible we get an hour's worth of opinions this morning. There are 18 outstanding decisions that have yet to be released from argued cases this term. Typically, the Supreme Court rises for summer recess, meaning they get all of their opinions out by the 4th of July holiday weekend, which is a week from Friday. So a couple of weeks left. They seem to be on track for matching that unofficial deadline, but of course we don't know for sure. So I'm just going to give people some more color from what's been happening at the court this morning. I'll show you you can kind of see it's kind of hard to see. There are groups of protesters out in front of the court right now. I don't know why my phone is going sideways. Hang on a second, guys. Hang on. Bear with me. All right, let's see if that works. Okay. So there are mostly abortion protesters that have lined up outside the court. Pretty good group. Actually, this is probably the largest group that I've seen out here for opinion days. Misbehaving phones. Yes, misbehaving phones. All right, so we have 17 minutes until decisions come down. We can go through some of the outstanding decisions. If that's helpful, if that's fun for you guys. We had a group protesting earlier on immigration and asylum related issues. We're still waiting on that big case, Biden v. Texas, about the Remain in Mexico policy from the Trump administration, and that requires individuals who are seeking asylum to remain in Mexico while they await the outcome of their asylum claim. And that case is about whether the Biden administration has to continue enforcing Trump's Remain in Mexico policy. The Fifth Circuit, the lower court, ruled against the Biden administration. So it's possible that that case gets kicked out on jurisdictional grounds because the court asked for additional briefing on that issue. But we'll see. But there are a lot of big decisions that are outstanding that aren't just abortion related. There's a huge gun rights case That is the oldest, now longest standing pending case that hasn't been decided on the court's docket from this term. That case was argued in early November. The court has already decided all of the November sitting cases, except for that one. And they've decided all of the October ones, and a number that were even argued as recently as April. That case is arguably the biggest Second Amendment case the Supreme Court has or will decide in over a decade. And it has to do with a New York regulation, a New York law restricting concealed carry permits. And it requires, if you want to get a concealed carry permit, which you have to do in order to conceal carry lawfully, you have to show what's called proper cause in the state of New York, which is something above and beyond just wanting to carry the firearm. And gun rights advocates argue that that restriction, that additional hoop that individuals have to jump through in order to get the concealed carry permit, that restriction violates the Second Amendment. And it seemed, from oral argument, the court was, at least a majority of the court, there were at least 5 justices who were poised to agree with the gun rights advocates there. A number of the justices have written that it is perhaps time to revisit the court's Second Amendment jurisprudence to clarify the right and how expansive it is. So that case is certainly a vehicle to clarify and expand our understanding of the Second Amendment right to keep and bear arms. And just because that case is out of New York and has to do with the New York concealed carry permit regime, it would affect states across the country, particularly those who have similar laws. For example, in Maryland, just across the water, it's not a proper cause showing, but it is a substantial, you have to show a substantial and good reason in order to get a wear and carry permit in Maryland. So that law would presumably be impacted if the Supreme Court decides to strike down the New York provision. So it's certainly possible we get that one. Also major decisions on climate change, religious speech, the case of the praying football coach, Coach Kennedy, up in Washington, who takes a knee at the center of the football field after football games to say a prayer. His case is pending. School funding out of Maine. So there's just a lot of interesting cases that aren't just the abortion one. I know a lot of you are waiting for the abortion decision, as are we, but there are a number of big cases that we're still waiting on from the Supreme Court, and each day that we have opinions, it becomes more and more likely that it is one of those. So just an update, the Supreme Court this morning released what's called their orders list, which they do at the beginning of the week, usually when they're during the term. And it is a list of all of the cases that they have decided to reject and say we're not going to hear those cases, and the few cases that they decide to hear. They get thousands and thousands of applications from individuals asking for their case to be heard by the Supreme Court. The Supreme Court now hears between 60 and 70 cases a year. So a very small percentage of those cases get granted. And an orders list is when the Supreme Court puts out the list and says these are the ones we're not going to hear. These are the few cases we are going to hear. So this morning the Supreme Court granted 2 new cases. All right, so 12 minutes until the Supreme Court will begin releasing opinions. I'll talk you through each of them. All right, guys, so T-minus 11 minutes until we get one or more opinions. from the Supreme Court. I'll walk you through each of them as they come down. If you want to follow along yourself, SCOTUS blog will be posting each of the opinions live on the website, but also you can go to supremecourt.gov, opinions of the court in the top left, and you can just hit refresh along with the rest of the Supreme Court press corps as we wait for the opinions to come down. A reminder for folks who are new, who are just joining, the way that this works. The court will begin releasing opinions at 10. If there are multiple opinions, they will release them in 10-minute increments. So the first opinion at 10 a.m., the second at 10:10, the third at 10:20, the fourth at 10:30, and so on and so forth until we get the final opinion of the day. For those of you asking, how do we know if it's the final opinion of the day? And I'll show you. So the Supreme Court drops the opinions on their website, and this is what it looks like on the opinions page. And you see this column right here that has an R number, a record number. That column will be empty until the final opinion of the day is released. So when we get an R number today in the column, that's when the final opinion is out. So I'll be able to tell you, you'll be able to see for yourself if you're interested, how many and when the final opinion comes down. So I know a lot of folks are waiting on abortion. We are as well. But there are still some major decisions from the court, including on the Second Amendment, on climate change, on religious speech. Biden v. Texas, there were immigrant rights protesting the Biden v. Texas case, which has to do with whether the Biden administration will be required to enforce a Trump-era immigration policy called Remain in Mexico, which asylum seekers seeking asylum in the United States at the Mexican border have to stay in Mexico pending the outcome of their asylum claim. Of course, the abortion decision. There's another religious funding, religious rights, religious First Amendment case out of Maine. It's called Carson v. Macon. And it's a challenge to a Maine tuition assistance program that pays for some students to attend private schools, but excludes schools that provide religious instruction. So it's for people who live far away or not near high schools, and Maine provides tuition assistance to be able to pay for some students to attend those private schools that are closer. But it excludes schools who provide religious instruction. There's an interesting case, if you guys may remember, the Trump administration, under the Trump administration, President Trump signed the First Step Act, criminal justice reform, major 2018 criminal justice reform law. There is now a case about that law and what factors a district judge should look at when considering a prisoner's request to reduce a sentence under the First Step Act. So that one also could be very interesting. T-minus 8 minutes until we get one or more opinions. It's going to be more. Pretty solid group of protesters here on both sides of the abortion issue, mostly abortion-related protesters. Hopefully you guys can hear me all right. All right, 7 minutes until the Supreme Court begins releasing opinions. Can we see the group gathered? Yes, hang on a second. Hey, Anthony, can I get you to scoot that way just for a second? No, just this way. I'm just going to turn the camera for a second, that's all. Thank you. You can see, there you go. Now you can see kind of the group that's gathered out there. A lot of media folks. And now my camera's going to do the wonky thing again. Oh, there we go. Ha 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 ha. I think I figured it out. I think. Maybe I just need to get a new tripod after this Supreme Court term. It's not great. Yeah. I don't know why it's doing this. Okay, it's going to stay like that. All right, that's the only look of the protesters you get unless something crazy happens because my camera will keep getting messed up. All right, so T-minus 5 minutes until we get one or more opinions. Go to supremecourt.gov if you want to follow along. Also go to SCOTUS Blog's website, scotusblog.com. We've got a live blog going there where James and Elena and Amy and Mark are talking through potential decisions that we'll get. All right, 3 minutes. T-minus 3 minutes until we get at least the first opinion from the Supreme Court. We have officers, Capitol Police officers who have lined up in front of the Supreme Court now between the two barriers because about 30 minutes ago, two individuals hopped the smaller fence. You can see the smaller fence behind me. Hopped the smaller fence and handcuffed themselves to the taller fence. They were pretty quickly removed from the fence. The officers cut the handcuffs and then quickly removed the individuals. They tied their hands behind their back some way. I couldn't see if it was handcuffs or zip ties, but they removed the individuals. So now a group of Capitol Police officers are standing in between the two barricades, presumably to prevent that from happening again. They were pro-choice protesters. All right, 2 minutes, folks. 2-minute warning. All right. We'll begin getting opinions in 1 minute. All right, about 30 seconds. I'm going to take my last swig of coffee here, and we will begin. So again, how this goes, the Supreme Court will release opinions, if there are multiples, every 10 minutes. So the first one will be at 10 a.m., the second one at 10:10, the third at 10:20. And I'll be able to tell you when it's the final opinion of the day. It's 10 a.m., so I'm going to begin refreshing the Supreme Court's website. The decisions are also released in order of reverse seniority of the justices. So whoever's authoring the opinion, they go in order of reverse seniority. Of course, Justice Amy Coney Barrett being the most junior justice, Chief Justice Roberts having the most seniority on the court, even though Justices Thomas and Breyer have served on the court longer than he has. He is still the most senior because he is the chief. So we'll be able to tell who has an opinion, maybe, or who doesn't have an opinion for the rest of the day once we start to get the authors of the morning's opinions. The first decision of the day, Marietta Memorial Hospital Employee Health Benefit v. DeVita. It's a Justice Kavanaugh opinion. The page is not loading from the Supreme Court's website. I can see it appear. And when I click the link, it says the page cannot be found. Let's see if that's happening to other members of the Supreme Court Press Corps. I'm going to hit refresh. Page can't be found. So there's a bit of an upload error. Can you guys, you're reading it now. Okay, for some reason I cannot read it. Hold on. It's by Justice Kavanaugh. The decision appears to be 7-2. Kagan dissents in part, joined by Justice Sotomayor. It's a short 12-page opinion. Here it is. I'm now able to pull it up. The opinion is by Justice Kavanaugh, joined by Roberts, Thomas, Breyer, Alito, Gorsuch, and Barrett. Kagan filed an opinion dissenting only in part, joined by Sotomayor. So this is a technical case about kidney dialysis and whether health insurance plans can pay low reimbursement rates for kidney dialysis for that procedure. Says this section of the law, section 1395YB1C, does not authorize disparate impact liability, and the Marietta plan's coverage terms for outpatient dialysis do not violate the law because those terms apply uniformly to all covered individuals. So, again, this is a technical case about insurance reimbursements for health insurance reimbursements for kidney dialysis. So the Supreme Court here sided with the health insurer, and they rejected a claim from one of the nation's largest providers for kidney dialysis, DaVita, that the insurer's low reimbursement rates violated federal law. So that is the first opinion. It is a brief 12-page opinion. Again, it's delivered by Justice Kavanaugh, joined by Roberts, Thomas, Breyer, Alito, Gorsuch, and Barrett. Kagan dissented in part, joined by Sotomayor. This case was argued March 1st. And we just got the decision. So this opinion is from Justice Brett Kavanaugh. As I was just explaining, the opinions will be released. This is not the final opinion of the day. We will get at least one more opinion. Justice Brett Kavanaugh delivered the opinion of the court, which means the rest of the opinions today, we will not get one from Justice Amy Coney Barrett. The opinions are released in order of reverse seniority. And so Justice Amy Coney Barrett is more junior to Justice Brett Kavanaugh, so we will not be seeing an opinion from her today. She had at least 2 last week, maybe more. So that would make sense. Her chambers were busy getting out last week's opinions. So the next opinion will either be from Justice Brett Kavanaugh or a justice more senior than him on the court, which is 7 others. So not much guessing to be done yet. Do senior justices write more important opinions? That's a good question, and it's certainly not always the case. However, the way that opinions get drafted and the way that opinions get assigned is the court takes an initial vote after they hear oral argument. They go into a room, it's called the conference room when the court has conference, and only the 9 of them are allowed inside that room. And the court takes an initial vote on where they are on the case after they hear everyone around the room speak. And based on that initial vote, the most senior justice in the majority assigns the majority opinion. If there is a dissent, the most senior justice in dissent assigns who writes the dissent. And so if, for example, it is a 6-3 split with Chief Justice Roberts in the majority, he can decide who to draft that opinion if all 6 of them align. And so he can assign it to himself if he wants to write that opinion himself, or he can assign it to another justice. There was some questions about why Justice Alito was chosen, at least initially, from the initial vote, to draft the majority opinion in Dobbs v. Jackson Women's Health. As we saw that leaked draft opinion come out of the court, that was drafted by Justice Alito. So presumably, if Chief Justice Roberts was in the majority, he assigned that opinion. However, the reporting from Politico is that 5 justices voted to outright overturn Roe, but Justice Roberts was not a part of that. He didn't agree with fully overturning Roe, if that reporting from Politico is accurate. So then, in the 5 justices who were poised to overturn Roe, Justice Thomas would be the most senior justice. And so he would have been the one, presumably, to assign the opinion writing to sorry, I'm doing 2 things at once. To do the opinion writing for the case for Dobbs. And so people were curious why Thomas maybe didn't assign that to himself, why he would have assigned that to Alito. It's interesting. But the way that it works is the most senior justice on any side of an opinion is the one who assigns who writes the opinion. So the question of, do the more senior justices write the most important opinions? That tends to be the case, but it's not always the case. What would happen if the person responsible for the leak was discovered? Well, I think they would have a tough time finding a job in law. That's pretty close to a career killer. But I'm not certain that they will find the leaker. The court typically divvies up the work pretty evenly throughout the term, with a justice writing a decision from each sitting. The court has sittings for each month: an October sitting, a November sitting, a December sitting, a January sitting, a February sitting, a March sitting, an April sitting. The term runs from October until they get the final decision out at the end of June. Can I explain the last ruling? Yes, because we have 2 minutes until we get the next decision. So it's a technical case in a dispute about health insurance reimbursements for kidney dialysis. And so this company who does a lot of kidney dialysis in the country was challenging the low reimbursement rates they were getting, saying it violated federal law from this health insurance, from a health insurer, and their claim got denied. So they challenged it and said the denial of that claim violates federal law, and the Supreme Court said, no, it doesn't. It's a very technical dispute. So I don't take broad brush opinions from that decision, and I can do perhaps a TikTok on that one later. It depends on how many we get today. But essentially, the health insurance, in the case over health insurance reimbursement rates, it was a disagreement over it. The Supreme Court sided with the health insurer in rejecting a claim from this company, who is one of the nation's largest providers of kidney dialysis. Now, I had a tricky time pulling this one up. You guys were able to pull it up more quickly than I was. Now it's pulling up. Okay, so the link is working. All right, it's 10:10. The next opinion is coming down. Going to drink coffee while I wait for the next opinion to come down. We're all just constantly hitting refresh on the Supreme Court's website. This will be the second opinion of the day.
If I say his name in front of you, I have to buy you.
Again, this last opinion was from Justice Brett Kavanaugh, so the next opinion will either be from Justice Kavanaugh or someone more senior than him.
So when Bucklock's name comes up, if you say
Second opinion, United States v. Taylor.
whoever you say it in
The
front of,
opinion of the court is delivered by Neil Gorsuch. This is a criminal law related decision on what constitutes a crime of violence. Justice Gorsuch delivered the opinion of the court, joined by Roberts, Breyer, Sotomayor, Kagan, Kavanaugh, and Barrett. Justice Thomas and Alito filed dissenting opinions. And the court held. Attempted Hobbs Act robbery does not qualify as a crime of violence under Section 924C3A because no element of the offense requires proof that the defendant used, attempted to use, or threatened to use force. So, again, this is a criminal case about the definition of crime of violence under federal law. So the Supreme Court essentially narrows the definition of crime of violence in a federal criminal statute, and the court agrees with the criminal defendant here that the definition of crime of violence excludes attempted robbery under the Hobbs Act. And the Hobbs Act defines robbery as unlawfully taking another person's property by means of actual or threatened force.
Back in 2004, like 4 hurricanes came across Florida.
The Hobbs Act, for those criminal law nerds, it's a federal law that makes it illegal to extort or rob by wrongful use of force or fear, or to attempt those crimes affecting interstate or foreign commerce. That's the first Hobbs Act. The second Hobbs Act makes it a federal crime to use a gun in connection with any crime of violence that can be prosecuted in a federal court. So the question here was whether it constitutes a crime of violence to make an attempted robbery under the Hobbs Act. And the Supreme Court said attempted Hobbs Act robbery does not qualify as a crime of violence because no element of the offense requires proof that the defendant used, attempted to use, or threatened to use force. Again, this decision was delivered by Justice Gorsuch, joined by Roberts, Breyer, Sotomayor, Kagan, Kavanaugh, and Barrett. This appears to be a 7-2 decision with Thomas and Alito in dissent. So what the Supreme Court did here was they narrowed the definition of crime of violence in a federal criminal statute by agreeing with the criminal defendant here that the definition excludes attempted robbery under the Hobbs Act. So the question kind of in this case is if a person commits they attempt to commit a robbery, but they're not successful, is the attempt alone a crime of violence? So in 2003, this guy named Justin Taylor sold marijuana not far away in Richmond, Virginia, and he and somebody he had with him, an accomplice, planned to steal money from this guy named Martin Sylvester, who was a prospective marijuana buyer. And after meeting Sylvester in the alley, Taylor's accomplice pulled out a semi-automatic pistol and tried to take Sylvester's cash while Taylor waited in a nearby getaway car. He was the getaway car driver. And Sylvester resisted, and the accomplice shot the guy who was going to buy marijuana. And Taylor and his accomplice fled, and they failed to get Sylvester's money. So it was an attempted robbery. They weren't successful at the robbery. Taylor drove the getaway car. And so he got prosecuted, and he was convicted under a plea agreement and sentenced to 30 years. But now he's challenging part of that conviction, saying that doesn't count as a crime of violence under the Hobbs Act, which makes it a federal crime to use a gun in connection with any crime of violence that can be prosecuted in federal court. So the Supreme Court agreed with him today in a 7-2 decision by Justice Neil Gorsuch. Justices Thomas and Alito dissented. So this case, as Amy's pointing out in the live blog right now, it was argued in December, and that gives Justice Gorsuch 5 opinions for the term so far. All right, so that's the second opinion of the day. We will be getting at least one more opinion of the day. There's no R number, so we're getting at least one more. And we are now up to Justice Neil Gorsuch. So that's the most senior Trump appointee on the court. So no more opinions from Justice Brett Kavanaugh today. As I explained earlier, opinions are released in order of reverse seniority of the justices. So the first opinion of the day was Justice Brett Kavanaugh. The second opinion of the day is Justice Neil Gorsuch. So we will not be getting any Amy Coney Barrett or any more Brett Kavanaugh opinions today. The next opinion, and there will be at least one more, will be from Justice Neil Gorsuch or someone more senior than him on the court. Can I do a recap of the opinions so far? Of course, the first recap of the day, and there will be several depending on how many we get. So the first case is called Marietta Memorial Hospital Employee Health Benefit Plan v. DeVita, and that case is about insurance reimbursement rates for kidney dialysis. So one of the nation's leading providers for kidney dialysis was challenging. They put in an insurance claim for reimbursement. They were getting really low reimbursement rates. And their health insurer rejected a claim from this provider of dialysis, and they challenged it and said that those low reimbursement rates violated federal law, and the Supreme Court disagreed. The Supreme Court sided with the health insurer. So the provider of kidney dialysis, DaVita, one of the nation's largest providers, lost on that one. That decision was 7-2. Kagan dissented in part. It sounds like she didn't dissent in full from that decision, and she was joined by Sotomayor. The second opinion is the one that we just got. We'll get the next one in 3 minutes. But that was United States v. Taylor, and that was about the definition of crime of violence, where the Supreme Court narrowed the definition of crime of violence in a federal criminal statute. And the court agreed with the criminal defendant here, saying that attempted robbery under the Hobbs Act doesn't constitute a crime of violence in this case. So, it's been an exciting morning here at the court. Lots of activity happening out front. Protesters on both sides of the issue. Probably 100 or so. Lots of media. And earlier, 2 protesters jumped this smaller fence behind me to get to the larger fence and handcuffed themselves to the larger fence, but they were pretty quickly removed. So we have T-minus 2 minutes until we get the next opinion for the day. Again, these are released in 10-minute increments. Amy's looking at the dissent in this case, where Alito agrees with Thomas that our cases involving the Hobbs Act provision in this case have veered off into fantasy land. Alito sounds upset in his dissent here. As someone is pointing out on the live blog, you guys can check me on this, but again, as I was talking about, the justices assign opinions pretty evenly across a sitting, a February sitting, a March sitting, a set of cases from that month. So with Justice Brett Kavanaugh drafting the Marietta decision, this individual is saying all of the Republican appointed justices except for John Roberts have a February opinion out, and all that's left is West Virginia v. EPA and Ruin. But it sounds like perhaps the Chief Justice might be drafting the EPA decision, which is a major decision about the Biden administration's ability to regulate greenhouse gases. All right, it's 10:20. Time for the next opinion. Let's hit refresh a bunch of times on the Supreme Court's website. All right. The next one, United States v. Washington. This opinion is delivered by Justice Breyer, and it's delivered by unanimous court. We jumped pretty big in seniority here. This is not the final opinion of the day. So this case is about whether the federal government has to continue to pay workers' comp claims of people who work for private federal contractors at the Hanford Nuclear Reservation. That's a federal-controlled piece of land in the state of Washington that was part of the Manhattan Project. So the Supreme Court has held that Washington's law is unconstitutional under the Supremacy Clause, that Washington's law facially discriminates against the federal government and its contractors because that provision does not clearly and unambiguously waive the federal government's immunity from discriminatory state laws. Washington's law is unconstitutional under the Supremacy Clause. There was a pretty big mootness issue in this case because Washington changed the law. The Ninth Circuit sided with Washington. So the court has reversed the Ninth Circuit. All right, so this is a Washington law that made it easier for certain workers made it easier for these workers to get workers' comp from the federal government if they became sick while they were cleaning up this decommissioned nuclear site that was a part of the Manhattan Project. The Supreme Court says the law violates the doctrine of intergovernmental immunity. This is Justice Breyer. It was a unanimous decision. So for those curious, and Amy's pointing this out on the live blog, this is the Supremacy Clause, which is what we're talking about here. That gives the federal government immunity from state laws that try and regulate or discriminate against the federal government, unless Congress has waived that federal governmental immunity, which Congress has not done here. Can you guys still see me? It says you lost connection for a second, but can you just want to make sure it's still going? Yeah, okay, great. All right. Again, this is not the final opinion of the day. The Supreme Court has just struck down a state law as unconstitutional under the Supremacy Clause. The law made it easier for certain workers to get workers' comp from the federal government. So this is a state law that made it easier for workers to get workers' comp from the federal government if they became sick while cleaning up this decommissioned nuclear site that was part of the Manhattan Project. And so the Supremacy Clause the Supremacy Clause generally protects the federal government from state laws that try and regulate it or discriminate against it unless Congress has explicitly waived that and said you can regulate us here. So the Supreme Court has struck down that law. It was a unanimous decision delivered by Breyer. So we made a big leap in seniority here. We went from two Trump appointees who were the most junior. The Trump appointees, the three of them are the most junior justices on the court. We had a first opinion by Kavanaugh, a second opinion by Gorsuch, and we jumped in seniority to Justice Breyer. So what that means is the next opinion will be from Justice Breyer again, or a justice more senior than Justice Breyer on the court, and there are only two justices more senior than Justice Breyer on the court, Justice Thomas and Chief Justice Roberts. So the next opinion of the day will be either Breyer, Thomas, or Roberts. It's possible we get a per curiam decision, which is an unsigned decision where we don't know who wrote it. But because we now have a Breyer opinion, the next one will be a more senior justice than him, or a per curiam decision, and that only leaves two justices who are more senior than him. Blake pointing out we did have a per curiam decision last week, so it's possible. So we have 4 minutes until the next opinion. How long between opinions? The opinions come out every 10 minutes in 10-minute increments. We got the first at 10, the second at 10:10, the third at 10:20. We will now get our fourth opinion of the day at 10:30. We do not yet know if that will be the final opinion of the day. Where do per curiam decisions fall in order of seniority? Good question. There is no technical seniority to a per curiam decision because we don't know who wrote it. We don't know who signed it. But the way that this works, or the way that the court has treated them this term, is they put out the per curiam decisions last. So after we get a Chief Justice Roberts decision, for example, that's when they would put out a per curiam decision, or after the most senior justice has delivered their opinion for the day. What does per curiam mean? So per curiam is an opinion that is released by the court. It is by multiple judges, and it is the words of the court and not one particular judge who signed on to it to write it. It's unsigned because we don't know who the justices are in a per curiam decision, unless we're able to count based on dissent. So for example, if there are 4 dissenters from a per curiam decision, then we'll know who the justices are in the majority, but we don't always know. All right, I can quickly go over the decisions that have come out today so far. We have 2 minutes, under 2 minutes until the next decision. So the first one was a technical dispute about reimbursement rates for kidney dialysis, and the Supreme Court sided with a health insurer and rejected the claims of one of the nation's largest providers of kidney dialysis, who was challenging low reimbursement rates as violating federal law. The Supreme Court disagreed and sided with the health insurer. Second opinion of the day, the court narrowed the definition of crime of violence to say that an attempted robbery under the Hobbs Act does not constitute a crime of violence in this particular federal statute. And so the court sided with the criminal defendant there. That was a 7-2 decision. Neil Gorsuch was in the majority. That case was United States v. Taylor. Thomas and Alito were in dissent in that case. And then the final one, the Supreme Court, not the final, the third decision, the Supreme Court struck down a Washington law that made it easier for people who were seeking workers' comp claims to be able to get workers' comp from the federal government if they got sick while cleaning up a nuclear site. But the Supreme Court struck that law down, saying it violated the Supremacy Clause. And now we are going to get the fourth opinion of the day in about 30 seconds. But that's the recap. It wasn't a successful robbery. It was attempted robbery for those talking about that case. All right. It's 10:30. It's time for the fourth decision. Again, these are released in order of reverse seniority of the justices, and we just got pretty senior because Justice Breyer delivered the opinion of the court about the Washington law. That was unanimous. The first opinion of the day was Justice Brett Kavanaugh. The second was Neil Gorsuch. The third, Breyer. So the next opinion will be Justice Breyer again, or a justice more senior than him, which only leaves Thomas and the Chief, or it'll be per curiam. This is Chief Justice Roberts delivering the opinion in Carson v. Macon. This is about the Maine Tuition Assistance Program. And the Supreme Court has held that Maine's non-sectarian requirement for otherwise generally available tuition assistance payments violates the Free Exercise Clause. So, this is a pretty big case. Ideological lines. This has to do with a Maine tuition assistance program where Maine provides money for some students to attend private schools, but they exclude schools that provide religious instruction from that supplemental financial support tuition assistance. The Supreme Court has struck down that Maine education program as violating the Free Exercise Clause of the First Amendment. They say the exclusion of religious schools is unconstitutional here. And again, this is a 6-3 decision along ideological lines. This is from Chief Justice Roberts, and this is not the final opinion of the day. So the next opinion will either be from the Chief or it will be per curiam. So let's look at the decision. It's a fairly short decision, 45-page PDF. The Chief opens the opinion with Maine has enacted a program for tuition assistance for parents who live in school districts that don't operate a secondary school of their own. And so under the program, parents designate the secondary school they would like their child to attend, public or private. And the school district transmits payments to that school to help defray the cost of tuition. Now, most private schools are eligible to receive this payment. These are Chief Justice Roberts' rules, language. Most private schools are eligible to receive the payments so long as they are non-sectarian. The question presented is whether this restriction violates the Free Exercise Clause of the First Amendment, and the court has held that it does in fact violate the Free Exercise Clause of the First Amendment. So the Supreme Court has struck down Maine's tuition assistance program that provides tuition assistance for students to attend some private schools but excludes schools that provide religious instruction. They said that that exclusion of religious schools is unconstitutional. Again, this is not the final opinion of the day. This is one of the major ones we've been waiting on. It's a 6-3 decision delivered by Chief Justice Roberts. I'm just going through the opinion here. This is from his opinion. The Free Exercise Clause of the First Amendment protects against, quote, indirect coercion or penalties on the free exercise of religion, not just outright prohibitions. In particular, we have repeatedly held that a state violates the Free Exercise Clause when it excludes religious observers from otherwise available public benefits. A state may not withhold unemployment benefits, for instance, on the ground that an individual lost his job for refusing to abandon the dictates of his faith. He's going through the recent applications of these principles. Trinity Lutheran Church of Columbia v. Comer, where they looked at a Missouri program that offered grants to qualifying nonprofit organizations that installed cushioning playground surfaces made from recycled rubber tires. There, the Missouri Department of Natural Resources had a policy of denying grants if they were controlled by a church, sect, or other religious entity. The Supreme Court struck that down. He's also going through Espinoza. Where they looked at a Montana program that gave tax credit to donors who sponsored scholarships for private school tuition. We again held the free exercise clause forbade the state's action. He calls these unremarkable principles. He says the unremarkable principles applied in Trinity Lutheran and Espinoza suffice to resolve this case. A state's anti-establishment interest does not justify enactments that exclude some members of the community from an otherwise generally available public benefit because of their religious exercise. So let's take a look at the dissent. We have 4 minutes until the next opinion comes out. So the majority opinion is about 18 pages. The dissent, a bit longer. This is Breyer, joined by Kagan and Sotomayor. The First Amendment begins by forbidding the government from making any law respecting the establishment of religion. It next forbids them from making any law prohibiting the free exercise thereof. The court today pays almost no attention to the words in the first clause while giving almost exclusive attention to the words in the second. The majority also fails to recognize the play in the joints between two clauses. That play gives states some degree of legislative leeway, Breyer says. It sometimes allows a state to further anti-establishment interests by withholding aid from religious institutions without violating the Constitution's protection for the free exercise of religion. In my view, Maine's non-sectarian requirement falls squarely within that scope of that constitutional leeway. I respectfully dissent. So this is not a surprising decision, as the chief points out. The court has had a trend of taking these types of cases and clarifying the scope and application of a state's ability to withhold public benefits that are available to everyone except for those who are religious. Justice Sotomayor wrote a separate dissent here. I'm just going to take a look at it for a second before we get the next opinion. This court continues to dismantle the wall of separation between church and state that the framers fought to build. Justice Breyer explains why the court's analysis falters on its own terms, and I join in all but part of his dissent. I write separately to add 3 points. First, this court should not have started down this path 5 years ago. She cites the cases that I just talked about that the Chief Justice mentioned. Second, the consequences of the court's rapid transformation of the religion clauses must not be understated. And finally, the court's decision is especially perverse because the benefit at issue is the public education to which all of Maine's children are entitled under the state constitution. As this court has long recognized, the Establishment Clause requires that public education be secular and neutral as to religion. She ends in a paragraph, "What a difference 5 years makes. In 2017, I feared that the court was," she quotes, "leading us to a place where separation of church and state is a constitutional slogan, not a constitutional commitment. Today, the court leads us to a place where separation of church and state becomes a constitutional violation. If a state cannot offer subsidies to its citizens without being required to fund religious exercise, any state that values its historic anti-establishment interests more than this court does will have to curtail the support it offers its citizens. With growing concern for where this court will lead us next, I respectfully dissent." So that's an overview of the 3 different written opinions here. We have under a minute until we get the next decision. So first opinion from Kavanaugh, second from Gorsuch, third from Breyer, and the fourth from Chief Justice Roberts. We are now at the top of the seniority scale of the Supreme Court now, so the next opinion will either be Chief Justice Roberts or per curiam decision. He is the most senior member of the court. don't know how many opinions are left after this. I just know that there will be at least one more. I don't know if we're going to get the decision in Dobbs today over. We'll see. All right, it's 10:40. We're going to get the next opinion. We're waiting for the next opinion, which will drop. It's supposed to drop at 10:40. We've gotten 4 opinions so far today. The final opinion of today, Shoup v. Twyford. We will not get Dobbs today. This is also by Chief Justice Roberts. Roberts delivered the opinion of the court, joined by Thomas, Alito, Kavanaugh, and Barrett. Breyer filed a dissenting opinion, joined by Sotomayor and Kagan. Gorsuch also filed a dissenting opinion. So it looks like this is a 5-4 decision. This is a man on Ohio's death road. His name's Raymond Twyford, and he's challenging his conviction. The jury never heard about evidence that a childhood gunshot wound left bullet fragments in his skull and impaired his cognition. The jury never heard evidence of that, and he says that the medical imaging of his brain now would support his claim that his trial lawyer failed to investigate and present evidence to the jury. And this is all part of a habeas proceeding. And a district court issued an order directing the warden to transfer Twyford to a medical center for neuroimaging, and the warden is challenging that transport order. There's several questions here, including one about jurisdiction. And the court has held a transportation order that allows a prisoner to search for new evidence is not necessary and appropriate in aid of a federal court's adjudication of a habeas corpus action when the prisoner has not shown that the desired evidence would be admissible in connection with a particular claim of relief. So here the Supreme Court has sided against the convicted defendant, Raymond Twyford. There was a question about the All Writs Act in this case. The court doesn't reach it because the court agrees with the state's second argument that the transfer order here was not necessary and appropriate in aid of the district court's jurisdiction because Twyford couldn't show that the evidence he hoped to find would be useful in his habeas case. So that is the final opinion of the day. The Supreme Court rules on All right, so those are the 5 opinions for today. That's it. All right, so you guys want a recap of all of the 5 decisions, and I shall do it. Let's go back to the first one of the day. So that case was Marietta Memorial Hospital Employee Health Benefit Plan v. DaVita. And it was a technical dispute about health insurance reimbursements for kidney dialysis. And there the Supreme Court sided with the health insurer, rejecting a claim from DaVita, who provides one of the largest providers of kidney dialysis in the country, that the insurer's low reimbursement rates violated federal law. The court said it does not. The second opinion, the court narrowed the definition of crime of violence in a federal criminal statute, and they said that attempted robbery under the Hobbs Act is not included in the definition of crime of violence in that case. So Neil Gorsuch delivered the opinion of the court. It was United States v. Taylor. Thomas and Alito dissented. That was a 7-2 decision. Third, the Supreme Court struck down a Washington law that gave individuals, certain workers who were trying to get workers' comp from the federal government, if they got sick while cleaning up a nuclear site. The Supreme Court said that law violated the doctrine of intergovernmental immunity. And that was United States v. Washington. Justice Breyer delivered the opinion of a unanimous court there in a substantial religious First Amendment case, free exercise case. The Supreme Court struck down a Maine education program that provides tuition. Struck down a Maine education program that provides tuition assistance to students to attend some private schools, but excludes schools that provide religious instruction. The Supreme Court said the exclusion of religious schools in Maine's tuition assistance program was unconstitutional. That was delivered by Chief Justice Roberts, and that was along ideological lines. That was 6-3. The final decision of the day, the court sided against an Ohio death row prisoner who was trying to develop new evidence to challenge his conviction and sentence. That was a 5-4 decision. Shoup v. Twyford. The three liberals, along with Justice Gorsuch, were in dissent. Chief Justice Roberts delivered the majority opinion in that case. Gorsuch says he would have dismissed that case without deciding it once it became clear that the court didn't have the power to hear the case. Breyer also said he wouldn't reach the merits in that case. All right, guys, so that's 5 opinions today. We are now down to 13 outstanding decisions from the court. We will get more opinions on Thursday morning beginning at 10 a.m. It'll go exactly the same way. We'll start at 10 a.m. I suspect we'll get multiples that day as well, and we'll get them in 10-minute increments. So the court is making a pretty significant dent in the number of outstanding decisions that they have. Again, typically the court ends the term and rises for summer recess right before the July 4th holiday weekend, which would be a week from Friday. That would be Friday, July 1st. So they have 13 decisions to get out between now and then, including some of the biggest ones left remaining, of course, abortion, the Second Amendment, climate change. There's another religious rights case about the case of the praying football coach, Coach Kennedy, who takes a knee on the 50-yard line after football games. So a number of major cases remaining. It's becoming more and more likely that those are the ones that we'll get perhaps on Thursday, but also perhaps next week. I wouldn't expect the court to get all 13 remaining outstanding decisions out on Thursday, but you never know, it's possible. We will find out the next opinion day, if there is another one, on Thursday afternoon, most likely, after the court meets for conference. They meet for conference on Thursday after we'll get opinions that morning. No per curiam opinions today. Sorry if the audio is bad, guys. I wonder if it disconnected from my headphones. Anyway, that's it. 5 opinions today. Oh, good. Glad audio is fine. Thank you, guys. The climate change one is about the Biden administration's ability to regulate greenhouse gases, West Virginia v. EPA. Protesters are slowly walking away. Nobody else chained themselves to the fence, handcuffed themselves to the fence. I do not think that the Dobbs decision will be per curiam. I think a justice will draft that one. And perhaps it will be Justice Alito, as is the draft. They don't have to release all of the opinions before the July 4th holiday weekend. There is no rule. The Supreme Court can do as it pleases, but typically they get them all out. It's an unofficial deadline. They get them all out by the July 4th holiday. Lots of crazy things have happened this term, so you never know. You're welcome, RoboSwap. So Thursday or next week. Yes, that's right. Rob asking for more recaps. Thanks, Pashwa. Thanks, Spilka 17. Yes, I do have security. No more opinion runners. You're welcome, Josiah. BSA 1982. Yes, pretty big decision in the Maine tuition assistance program. Chief Justice Roberts delivered that decision. Thanks, Marlo. Yes, I'll be back on Thursday, of course. We'll be back for every opinion day this term. You're welcome. All right, guys, I'm going to go do my other day job. I will make a TikTok video. Thank you all. All right, guys. I'll see you Thursday morning, 10 a.m. Set your alarm. We'll be here. All right.
So you're not talking on a streamer or anything.
Are we off that now?
Well, it's still up,
Yeah.
but you're done.
They have cleared us?
No, that's what I'm asking.
Oh, I'm done. Yes. Yeah, I'm done. I don't know if they're still streaming on our website.